Welcome to the DRE Way, where we discuss current events, frequently asked questions, and legal matters. When it comes to law, the only way is the DRE Way. Hello, everybody. Welcome back to the DRE Way on another great Wednesday afternoon. We're happy to have Darren Richie back with us again. Darren, thanks for making time in your schedule.
You're welcome, Matt. Nice to be back.
Okay, so in our last podcast, we were talking about the defamation cases with the Kardashians and with Johnny Depp and Amber Heard. And you brought up a concept that we didn't have time to get into, but it's come up personally for me in the office talking with some other attorneys this week and doing some case reviews, and that's burden of proof. And so I wanted to kind of ask you some questions about that. What is that? What is burden of proof?
Okay. Well, I think the best way to start framing this subject is to ask you the same question. And here's why. Because when you get into a criminal or civil court case, you have a box full of jurors, and those jurors are going to be our peers. And they're going to look, act, and talk just like you. So if you were sitting in a box and somebody were to say, that there is a measurement tool that you needed to bring out of your toolbox, and it was called burden of proof. What do you think it means?
To me, it would seem to mean, we have to prove, I always believe somebody's innocent until proven guilty in this country, but I am at least a little bit familiar with some different types of court cases. Like for me, I know there was 2 cases brought against O.J. Simpson. Was one that was readily come to mind where he was not proven guilty in the criminal courts, but in civil court, I think he actually lost, and because it was likely that he did it or something, like they didn't
Right.
have to prove as much that he actually did it or not.
Yeah. So you're heading in the right direction. I think it's very interesting. Lawyers take for granted, that they have a lot of information at their fingertips, and they clearly understand these concepts and subjects, but yet the people that are actually going to be deciding on people's lives, liberty, and financial outcomes really don't even sometimes know the difference between a criminal case and a civil case. That sometimes confuses a lot of people. We'll get phone calls, for example, asking if we can prosecute people for crimes.
Right.
We're private attorneys. We don't do that. Government
Correct.
attorneys do that. Either an attorney for the federal government or an attorney for state governments or the attorneys for civil governments. We don't play that role, right? But
Hmm.
the context really comes up depending on what the backdrop of the case is. So if you're in a criminal case, all criminal cases require a burden of proof, which is called beyond a reasonable doubt. But just describing what burden of proof is quite important itself. Burden has a connotation that you're carrying something that's heavy, and it requires you to understand and appreciate that weight. Well,
Okay.
that weight and that burden is on the prosecutor in a criminal case. And it's their burden to prove something. That's why it's called the burden of proof. And
Okay.
so we take apart that 3-word phrase. We start with the burden. Now you know that it's residing upon the prosecutor. And then the proof can come in all different forms, but it could be documentary evidence, it could be testimony, it could be videos, it could be photos. There's a whole host of different types of evidences that are presented, right? So
Okay.
witness testimony, and so the burden is to prove their case beyond a reasonable doubt. If they don't prove their case beyond a reasonable doubt, then the person is not guilty of the crime. And that goes for misdemeanors, it goes for felonies, and you also must get a unanimous verdict. So if you had 12 people here in California sit on a criminal jury trial, all 12 have to say that the defendant is guilty beyond a reasonable doubt in order for the burden of proof to have been performed. Okay. And
Okay.
so
Well, what
beyond, yeah,
happens? Sorry, real quick. What happens if somebody doesn't? If there are 12 and one person is holding out that they don't believe it, what then happens?
that's called a mistrial. So if
Okay.
1 out of the 12 or 11 out of the 12 Anywhere in between think that the person might not be guilty and they say that the person is not guilty, then that's a mistrial. Because in order to secure a conviction in a criminal case in California, there must be a unanimous verdict and it must be beyond a reasonable doubt. Now
Okay.
let's take a look at the burden of proof called beyond a reasonable doubt.
Right.
It's so convoluted and it leaves open a lot of interpretation that has been litigated for hundreds of years, really, through the court systems. But essentially, it means that to a reasonable degree of certainty, there remains no doubt that the person that is sitting before you as a defendant in the trial is guilty of the crime charged. That's what it means. And there's a qualifier in front of doubt, which is called reasonable. So, of course, we could come up with all kinds of different doubts, right?
I was gonna ask, like, reasonable is a very
Right,
ambiguous term. It's kind of, what's reasonable to you might not be reasonable to me. Like,
right. But it really means it can't be a preposterous doubt. So it has to, if a reasonable doubt remains in the lap of a juror, then the person is not guilty. If
okay,
if you are beyond a reasonable doubt and all of the evidence before you is deemed credible and it only really points in one direction, that this particular defendant was guilty of the crime charged, then you've carried that burden as a prosecutor. Okay.
okay,
So if we were to look at a scale, essentially, burden of proof is the highest standard of proof, the highest burden of proof, the
okay.
biggest burden, the most weighty burden. And
Which makes
really,
sense because it's criminal. It's putting somebody in jail. You're affecting that individual's life for.
right. So a lot of times, if person X is being accused of a murder, and a defense attorney comes up with a theory that, well, person Y might have done that, then that means that there's some doubt there. Because if a
Hmm.
juror says all of the evidence I heard about person Y makes me believe and doubt that this defendant is guilty, that would be a reasonable doubt, and therefore the defendant would not be guilty. Okay. So it's
Okay.
almost a reasonable degree of certainty. You have to almost come to a factual and legal conclusion that's so clear that there's really no other explanation besides the one that the prosecutor has offered to you,
Got it.
clearly marking your client as guilty. That's what beyond a reasonable doubt is. So going to preponderance of the evidence, and by the way, there's kind of an in-betweener that we'll discuss right after this.
Sure.
But preponderance of the evidence is for a civil case. So to go with your O.J. Simpson analogy, they didn't have enough evidence to convict O.J. Simpson, apparently, with that particular jury, of guilt beyond a reasonable doubt. Because
I
if
know
it
they did the
fits,
glove doesn't fit.
a
It's
glove,
yeah.
if the glove
He
doesn't
must
fit,
have
you
quit.
must quit, and all that kind of stuff. So they were thinking, well, shoot, if the glove doesn't fit, then they must not be his gloves. And then, of course, there was a bunch of evidence about racially charged detective work and
Right.
planting evidence, and there was some doubt, I guess,
Hmm.
in those jurors' minds, and so therefore he was not found guilty beyond a reasonable doubt. But with a different jury in a civil case, you now are at a preponderance of the evidence. And
Okay.
preponderance of the evidence varies in contrast from beyond a reasonable doubt, where I said beyond reasonable doubt is kind of all the way at the top.
Hmm.
Preponderance of the evidence is right in the middle. So if it is just more likely than not that the person is guilty of whatever you're charging them of in a civil case, then it can go just one notch above 50%, and that would be enough to carry that burden.
So that's
Further,
fascinating because
further,
that's
you don't need a unanimous verdict. In
right.
California, you need 9 of 12. So
Okay.
3 jurors out of 12 can think, oh, I don't buy anything that this plaintiff's attorney is bringing here in this lawsuit.
And they
And
can
then
still
9
lose.
of the 12 could say, hey, 49% of me thinks that it may not be likely, but 51% thinks that it's more likely than not. So if it's just a tad above whether or not it's possible and it's more likely than not, then you've carried your burden. And that's preponderance of the evidence.
See, that almost seems like even a harder fight to me than beyond reasonable doubt, just because there is that wide room for, well, 51% is all it really takes that they're likely, rather than being, yes, they, there's no reasonable doubt that they didn't do it.
No, for a jury and for a prosecutor or a plaintiff, burden of the proof beyond a reasonable doubt is harder because you've got to
Yeah.
make sure that there's no doubts that remain. With preponderance of the evidence,
Well,
you
I
can
meant
have thousands of
from a
doubts
defense
remain.
side,
Oh, from a
from our
defense
side.
side. From a
Yeah.
defense side, yeah, from a defense side, it's harder on civil. That's
Yeah.
true. And then it is on the criminal side beyond a reasonable doubt. If you can demonstrate reasonable doubt, whether it's by alibi or another person did it, or showing that the evidence was faulty in some
Mishandled.
respects, there's some doubt there, and you can't convict the person in criminal. But if there's more evidence that says that he did it than not,
Not
then you would
in
be able to
civil.
sustain a jury award or judgment in your favor in a civil case. So, yeah, that's correct. Depending on which hat you have, it's either harder or easier. Okay.
That's
So,
very
in
interesting.
between is called clear and convincing evidence. And there's a whole bunch of different types of cases this is used in. Uh,
Okay.
it's used a lot in certain different motions, but things that might resonate with your audience would be if you're trying to get a conservatorship upon somebody, where you want to control somebody else's financial affairs, or
Kind of going to the Britney Spears thing that was recently in the news. There's actually been a lot of actors that have had conservatorships. I can't remember the other ones, but she was the big one.
yeah, or if you're trying to terminate a parent's right to keep their child, that would be a clear and convincing. And so if preponderance of the evidence is right here in the middle of the road and beyond a reasonable doubt is at the top of the road, clear and convincing evidence is just below beyond a reasonable doubt. Um, that is usually a determination that a judge makes, and he must be substantially satisfied that whatever it is that's being alleged is actually true. It doesn't necessarily mean that there is no doubt whatsoever that this person did it, but it just says, hey, all indicators are pointing to this particular conclusion. So therefore, it's just a bit under. At the carnivals or the festivals, there's this game, and usually a lumberjack or a strong guy would hit something, and it goes all the way to the top. And you think about a thermometer, the top would be beyond a reasonable doubt, and about 10 degrees below that, maybe 90% certainty would be clear and convincing. So another way to
Okay.
frame it would be 97 to 100% certainty would be beyond a reasonable doubt. 90% certainty would be clear and convincing evidence, and 51% would be preponderance of the evidence. And we've used a lot of words right now, and I don't know how
Yeah.
many minutes to describe these three burdens. And you can see how hard it is to actually try to articulate it. And it's very difficult. So when you're talking to a jury for the first time and you're trying to explain to them what their job is going to be, you can see how hard it is, because you've got to use a whole bunch of different examples to try to get people to understand how they're going to have to, reference this particular action, and determining whether or not someone's guilty or not guilty, or whether or not they should win a case or lose a case. So, reasonably certain would be beyond a reasonable doubt. Fairly convinced would be clear and convincing evidence, and more
Hmm.
likely than not are kind of some buzzwords for preponderance of the evidence.
So you guys actually almost have to coach the jury and explain this stuff to them to help them understand what they're really up against.
Oh, absolutely. So you're not allowed to do that in the opening arguments, but in closing arguments, the jury is going to be getting instructions from the judge, and in those instructions, they're going to instruct the jurors as to the definition of what these standards and burdens of proofs are. But in closing arguments, you get to then take all the evidence that was presented and then connect it to or contrast it from these burdens. So if you're a defense attorney, you'd say, look, I told you about Mr. Y. I told you about
Mm-hmm.
Mr. B and D, and all of those people had motive and opportunity to commit these crimes, and they also had the means to commit these crimes, and they did not have alibis, and a piece of hair from these individuals was found at the scene, so they could be the actual killers, and therefore that is doubt. And as you know, Mr. Jury, you're not allowed to disregard certain evidence that you've been present and hearing, but you get to determine and weigh the credibility of it. And if there is doubt that remains at the end of the day, then my client must not be guilty.
Okay. I mean, that's a very good argument. So the instructions come at the beginning from the judge?
The instructions come at the end before the
Okay.
jury goes to do something called deliberation, which is what you've probably seen in the movies when they go back into a room and it's hot and there's like sandwiches and people are getting upset with each other because, 11 people think he's guilty and one thinks he's not guilty. And there's that lone holdout and they're all trying to convince the person to, vote their way so they can get out of there for the weekend. Yeah, so before they get the actual case, they get the instructions on reasonable doubt. But a lawyer gets to argue that in closing argument. And then once
Right.
closing argument is done, the jury instructions come and then the jury deliberates.
That's just interesting to me because I almost just as a personal preference in my mind, I would want to know that going into a case just so I could, as I'm looking through the evidence, it's become, at the very end that all of a sudden I have to think about, wow, was I really convinced or not? Almost seems unfair versus knowing it right at the beginning. And that's just, the way my mind works around this is I'd rather know those rules up front going into a case.
Well, you can touch on those during a process called voir dire, which is maybe something else that we would talk about at one of
Okay.
these podcasts. But when you first get to meet certain prospective jurors and start beginning your selection process, you can describe, some of those burdens of proofs, and that kind of plants the seed in the juror. But then later, once the case is done, you get the actual very distinct codified jury instructions.
Okay, that makes sense. I did want to go back real quick to that middle 90% proof that you were talking about. Something you mentioned there kind of caught my mind, which was a parent losing parental rights over their child. And we get a lot of DCFS calls. We get a lot of child custody, family situations, and we handle these matters.
Right.
You mentioned that it kind of comes down to like a judge's opinion on that of where that sits. And we've had this before where people have said, "Oh, this judge just doesn't like me." How much of that, like, can you get a different judge on a case? Is there, because a jury, you're talking 12 people, there can be different opinions, but if you've only got one judge, it can kind of seem a little unfair in terms of like proving and stuff.
Not just related to this particular practice area, but there is a tool and a mechanism called 170.6. It's out of the Penal Code 170.6, where you can go ahead and strike a judge once preemptively and get yourself in front of another judge. So if you believe that there's any bias for any particular reason, or if you want to take advantage of this statute, even for no reason at all, you can just say, hey, I'm exercising my one time right to get to another judge. And then you can. However, I'll tell you that a lot of times, and especially in DCFS cases, which is Department of Children and Family Services, a lot of times in those cases, the judges in the trial level may make one decision, and then those decisions get appealed, and those appeals overturn those judges' decisions because the
Right.
judges are just churning through these. And obviously, there's a lot of allegations that fly around with regard to that practice area, and oftentimes, at least from our perspective, they're false allegations. Just because somebody
Correct.
says something doesn't mean that it's true. And a disgruntled ex-girlfriend or wife may say something bad about husband or boyfriend, or vice versa. A disgruntled
Correct.
ex-boyfriend or husband may say something bad about an ex-wife or girlfriend, and that alone shouldn't be able to disconnect a mother from a child or a father from a child. So we make sure that that process is followed, but sometimes it won't go our way and we'd have to appeal that decision. But when you get to the appellate sources, And those judges, they take a hard intellectual and legal look at it. So that's where this
Okay.
burden of proof would come in. So with regard to
Right.
convincing evidence, they would take a look at the trial record and say, I don't believe that the trial court considered these elements or factors that were on the record at the time. And they should have, because if they had done that, then the clear and convincing evidence burden would not have been met. So, that's part of what we do on a day-to-day basis, is making sure that every I is dotted and every T is crossed to the benefit of our clients.
And I really, and I know you guys do that. I mean, I see that every single day, and I think that should really give a lot of people some degree of hope, I guess, when they get in these situations. I mean, it's scary. You know, take a criminal case or even a DCFS, Department of Child Services case. You're potentially looking at losing your kids and your family. That's a lot on their shoulders that we end up helping out because we're dealing with this proof and everything. And to your point, just because somebody said something, while it is testimony, it is a witness statement, it is evidence, it is not definitive proof up to that mark necessarily,
Right.
where you guys would have to go, okay, yeah, they're guilty.
And you could have a battle of testimony. One person says something and another says another. That's back as old as he said, she said.
Especially
You
closed doors inside the house,
know? Yeah.
no evidence. Yeah,
So
that
the,
gets
the
ugly.
fact finder gets to weigh those. Was the person being honest, or was there any other supporting evidence that makes it more believable? And that's
Right.
how they come to those determinations.
Okay. That I think that's really been very enlightening. I've really enjoyed this. I learned a lot out of it. You know, I came into this with, well, you're innocent until proven guilty, but that doesn't always seem to be the case. And there's not a lot of these discussions out there to help the general public understand what this
Right.
is. Like you said, the attorneys have this, but we as general public don't know that. And so it's kind of like, oh, man, what are they going to get on me? How bad is this going to get?
And that is, well, in the podcast, how we started it, that's what I find so fascinating, because it's the general public that makes these decisions that impact people's lives. I mean, we go to criminal courts where somebody can go away for the rest of their life, or in fact, entertain death penalty sentences. And that all
Hmm.
starts from a jury. So, of course, here in California, the death penalty phase, goes to a judge, but a jury can certainly decide on a murder charge and put somebody away for the rest of their life without the possibility of parole. And these are people who've never even heard of the three words together, burden of proof, anytime in their life prior to sitting on that jury.
And they're held to the responsibility of making those
That's
decisions.
right.
That's scary, and hopefully the attorneys do a good job of explaining that. And I mean, hopefully nobody ever has to come up against that,
It's
but it
hard to
happens. And
explain, though. I mean, we
yeah,
took 23 minutes or whatever it was,
correct. Yeah,
trying
about
to give
25.
you examples, but it's not concrete and it's hard to articulate.
It very much so. I mean, really, when you're talking those percentages, even, do I believe it 50% or is it 49? Like,
Right.
that's a very hard to define line for anybody to make a decision on that. And so
Right.
that definitely makes a jury's job very difficult.
Yes, sir.
Well, Darren, I really appreciate you clearing this up for us. We look forward to having you next week. We'll definitely get into some more cool questions, and thank you for making the time again.
All right. Thank you. See you
All right,
soon.
have a good one.
Bye.
Bye.